If you're always on your iPhone, your Droid, your BlackBerry returning emails after hours, should you be compensated for it? We're joined by WGY legal analyst Chas Farcher of Martin, Harding and Mazzotti. Good morning.
Morning, Kelly.
So this is the subject of a lawsuit that's now in federal court. Some police sergeants claim that they were forced to respond to emails and company calls on their company-issued BlackBerries. So, and they're trying to get back pay and OT for that time they put in after their regular shift. Do they have a case?
Yeah, I bet you didn't know that all those emails Chuck's been sending you all hours of the day could get you to retirement a little quicker.
Yeah, well, it's going to entitle me to something.
I hope to God I don't have to compensate her for that. I'm going to owe her a fortune.
You know, the law that's at issue here is the Fair Standards Labor Act. It's probably more well known for the law it's the law that sets the minimum wage and requires employees to be paid time and a half if they work more than 40 hours a week. There could possibly be a case here. There are some practical concerns for the Chicago Police Department. Where the lawsuit is right now is that the federal court has just said that it can proceed, that they've made the minimum showing to say that they could possibly have a case here. So, the officers still have the practical problems of proving that they were actually working during the time that they say they were, that the work was not just de minimis, reading an email here for 30 seconds or reading an email there for 30 seconds. And they were also allowed to use those PDAs that they were given for personal use. So all the time they spent on them was personal use, was work. So there's a lot of practical concerns with the lawsuit. But if they can establish that they were actually putting in significant hours, then yeah, they should be compensated for that overtime.
Now, does this have a broader implication to other industries as well? And is there a difference between hourly employees and salaried employees? Because with a salary, it's kind of implied that you'll put in extra time, you're compensated for it elsewhere.
Yeah, the Fair Standards Labor Act is pretty specific. Most people would be exempt from having any type of claim like this because if you are salaried, you're exempt from overtime pay unless you have some type of specific labor agreement. So, if you're a salaried employee, you wouldn't have a case here. If you're high-level management or if you're some type of professional, all of those classes of employees are generally exempted from the Standards Labor Act. So it first depends upon what type of employee you are, and then, like I said, then you also have the practical difficulty of actually establishing if you're using your phone, is it specifically for work and for how long.
Speaking with legal analyst Chas Farcher from Martin, Harding and Mazzotti. So what about if you're an hourly worker? Can you be expected to respond to emails or texts when you're off the clock, so to speak?
Yeah, absolutely. If it's part of your job, it's part of if it's in your job description, it's implied that's what you're supposed to be doing. But what has to happen is the employer's got to have a process where you can thereby claim the time that you're working and put in for overtime. It's the employer's obligation to keep that process, that channel open and available, and it's the employee's responsibility to make use of that channel and actually put in for that overtime. The police department, in this case, has a process whereby the officers can claim the overtime if they believe they've worked significant hours on their PDAs. And I was looking at some of the testimony they've taken in the case. But, there are officers who actually have put in for the overtime and have been paid.
Mm-hmm.
The question in this particular case is that the officers are claiming that not only is there a written policy whereby they can claim the overtime, but there's an unwritten policy that discourages them from doing so.
Yeah, I'm just wondering if there are some cases where some hourly employees, there's some level of interaction that can be expected for free without getting paid overtime.
Well, I think the test is de minimis. If your boss sends you an email and you got to read it and write a two-second response, I don't think you probably wouldn't be putting in overtime requests. If you're spending half hour, an hour a night, and by the end of the week you've worked 3, 4, 5 extra hours a week, I think that you should be putting in for the overtime, and there should be a channel for you to do so.
WGY legal analyst Chas Farcher of Martin, Harding and Mazzotti, 1-800-LAW-1010. Chas, thank you so much.
Hey, have a good day, guys.
You too.